Good morning, everybody, and welcome to Law and Crime. I'm Jussie Weber, joined here by trial attorney Bob Hille, and we're going to break down the biggest live trials and legal stories in the news today, and we have a lot to talk about, so let's get started right now. First up, I want to let you know that we are going to be live in day 3 in the trial of John Johnchuk. Now, this is the man who is accused of killing his 5-year-old daughter, Phoebe, by allegedly throwing her off a bridge in Tampa, Florida on January 8th, 2015. That's a picture of this young girl, just a horrible case. She was thrown 62 feet into the water below, and we believe the cause of death is drowning. It's a horrific case. The prosecution has charged him with first-degree murder, along with other charges, but the defense is saying, yes, our client did this. He killed his daughter, but the question is he legally responsible? Because they are arguing the insanity defense. We're going to have a lot to break down in this case, including Johnchuk's recorded police interrogation tape from yesterday that was played for the jury. And again, we do expect to be live any moment. I'm keeping a careful eye on the courtroom feed. I want to let you know that at around 2 p.m. Eastern Standard Time, we are also going to be live in a different courtroom. This is the arraignment for Jake Patterson, the man who's accused of kidnapping 13-year-old Jamie Kloss and killing her parents. He faces 2 counts of intentional homicide and a count of kidnapping and armed burglary. Based upon the statements of the defendant leading up to this arraignment, where his formal charges will be read and he can enter into a plea, we believe he is going to plead guilty. As you recall, that he has been writing letters to journalists talking about what he did, showing remorse, and saying that he plans to plead guilty. We don't know what to really expect, though. We have to go live, and we'll obviously see more in the Jamie Kloss saga. Well, let's try to make sense of something that doesn't seem to make a whole lot of sense. Joining me again is Bob Hille. Bob, what happened here? I mean, is it a sense, this doesn't really work this way, where you have a grand jury that throws out these indictments, and then all of a sudden, out of nowhere, the charges are dropped. Was it, you think, a lack of evidence on the part of the prosecution? Did they lose key evidence? Did they see that the witnesses that they were going to call maybe were not as credible? Was a secret deal made? Well, you tell me what you think happened here.
Well, it's very interesting in terms of the issue here, because it's really Mr. Smollett's word against the other individuals that they questioned. There were no videotapes that were really conclusive. There's no question he made the reports. So the real question is, how strong was the evidence against his version of the story? It is unusual when there's an indictment for the prosecution not to proceed, but if certain things happen with the case, a witness disappears, but we don't have any of that we know of yet here. What we do know is there was an agreement with the prosecutor, notwithstanding the defense side's position, because ultimately the court approved the request and the exercise of prosecutorial discretion to drop the case. What
I'm confused about is he admitting wrongdoing or not, because he agreed to forfeit his $10,000 bond and community service, and the prosecution's office, we feel good about this result, but they didn't quite exonerate him. They never said they exonerated him. He's still saying he was right. I mean, did he admit fault? Did he do something wrong or not?
That's interesting. You have 2 sides to an agreement saying different things about the agreement. One is saying it wasn't even an agreement. He's saying that he was without fault. The charges were dismissed. The prosecution is saying that's not an exoneration. That's their exercise of discretion to drop those charges for whatever, a number of reasons, community service and also the forfeiture of the bond.
If he was fully exonerated, we would have seen some sort of evidence come forward, clearing his name, the Chicago Police Department, the mayor's office. They would have all been on the same page. We made a mistake. We see this new evidence. That didn't happen here. This split between the Chicago Police Department and the state attorney's office, have you ever seen anything quite like this? They're not on the same page at all.
I can't recall anything specifically from my recollection recently, but I'm sure it's happened before, because very often the prosecution, for whatever reasons, will try and exercise its discretion to drop a case. The more high-profile the case is, of course, the more difficult that is, and then these issues get embedded into it. I think, you know, in a non-profile case, they do this, nobody pays attention to it.
Well, we're going to still break this down, because this is clearly not the end of the Jussie Smollett saga, including the fact that he may be investigated for a letter that was sent to him, and whether or not that was a hoax as well, and whether or not the federal investigation will be going underway for that. So we'll obviously let you know more. We have a lot more to talk about here on the Law and Crime Network, so stay tuned. We'll be right back. It seems to be whether or not an issue of him sitting in on the court. Can you help explain what's going on here?
Yeah, I'm not really sure I understand that argument, because generally sequestration is something that you have where you have witnesses who were there or involved in the underlying event, and they want to be consistent. You want to avoid that consistency. You want them to tell the truth. With an expert witness, they're not there. They're looking at the facts of the case, and they're giving an opinion. So I don't quite understand that. Generally, experts are allowed to listen to the underlying testimony. They're limited by what's on notice to the other side in terms of the scope of their opinion. But generally, they can draw on anything in the case for that.
And the defense doesn't want the prosecution's expert in because, again, the idea of sitting in on this, that might affect the testimony?
Yeah, I mean, that would seem to be the only reason that they're trying to do that. Although it's interesting because under the insanity law in Florida, the jury doesn't necessarily have to even adopt the state's expert because the defense has a burden of proof.
Sure.
So if they don't accept the defense expert's explanation for whatever the elements are for establishing that affirmative defense, then the defendant's not going to have that, and he's going to be found guilty. Right,
and this is a question about the mental health of the defendant. We're going to jump back live, and maybe we'll learn a little bit more about what's going on. All right, so these arguments are all outside the presence of the jury. They haven't been called in yet. Bob, again, what do you think the crux of this is? How does this, is this important?
Well, it's interesting. In the sequestration argument, which is the basis for trying to exclude the expert's testimony here, what they're saying in essence is where you don't have the defendant testify, there's really nothing for that expert to rely upon with respect to that defendant's side of the story as to state of mind. Also, the argument is that having the expert in the room during the state's case, and they're citing these Florida laws, allows the witnesses to try and give a layup for the expert. In other words, lay the factual foundation from their observations, what they did, their testimony, for the expert then to draw an opinion from.
Because isn't well, what is an expert supposed to testify to, just based upon his opinion or her opinion of the evidence and the facts, and perhaps their interview with the defendant in an earlier case, and not what was said in court in the courtroom?
Well, yes. I mean, the essence of an expert opinion is that the jurors can't look at the facts and the factual testimony and the fact witnesses and draw conclusions. They need assistance from someone with specialized knowledge. That's what the experts are there for. Now, it depends on the issue that specialized knowledge is being offered for. In this case, obviously, the state is not only to its mens rea obligation under proving the crime, which it seems like it's carried that burden, right, but in fighting against their argument that there's insanity in defense here.
I think we can jump back to court. There's some activity going on, so let's just jump back for a second. Okay, so it's all about the insanity defense, and in Florida, it basically means that if a defendant has some sort of mental disease or defect, and that would cause the defendant to not understand the consequences of his actions or not know what he was doing, or if he knows what he's doing and knows the consequences but just doesn't know that they're wrong, that might be insanity. So, Bob, you tell me, based upon what you've seen so far, can they make out a successful claim of insanity here?
Well, as you said, Jussie, there's two components to this. The first is whether you understand what you're doing and the consequences, or the consequences. And if you can't get past that tier, then it's whether you knew it was wrong. I think that's the part that's really going to be a difficult stretch for the defense on this case because of a lot of the actions and the evidence that's come in. And also, in the opening segment we just saw, the defense counsel, they never really talk about what component of the insanity law, which is a legal definition, not a medical one. And they do talk about his prior history, which the law says is not really relevant unless there's clear and convincing proof of it. So it's really a great challenge, I think, for the defense in this case.
And they seem to be going more towards the line of sympathy. You know, let's have sympathy for the defendant, what he was going through, but let's play more of the defense. Again, maybe they're going to be stretching out what this insanity defense really means and applies to the defense. So let's play a little bit more. Okay, but again, the question is, Bob, and you tell me, if he's running away from the police and driving away from the police, how could he really think that what he was doing was not wrong?
Well, again, it's interesting. I mean, I'm not an expert psychiatrist or psychologist, but obviously he recognized they were police officers. He recognized that he had done something that they were after him for, and he was trying to get away. That doesn't support an argument that he had no clue what he was doing that day.
Yeah, that's a good point. Just want to let all the viewers know real quick, and I'd like your perspective, Bob, on this. This judge just made a ruling in the court that the state can have their expert sit in for the testimony of some individuals, including other experts. Your thoughts on that?
Well, again, it's a discretionary action by the court, and I think the court's looking at it to say, well, the expert's going to need to rely upon the testimony, and that the judge is worried about the jury getting a quality expert opinion, and it's important to have that expert there. I mean, that expert's going to be limited by the rules of court with respect to not deviating from the opinion, and is going to be subject to cross-examination on the basis. But the idea is that the judge wants the expert to be able to testify consistent with the testimony in the case that the jury's hearing. And
I'm assuming that this expert by the state is going to testify to the fact that, actually, I think we can jump into court real quick. We're getting some activity, so let's just jump live for a second. Bob, I imagine this is going to be a very difficult day, particularly for the jury, as we get into the details of what happened to this young girl, Phoebe. I believe the cause of death may be drowning. If that's the case, what does that tell you?
Well, what it tells you is that this person most likely was alive when they hit the water. And as a consequence of that, you know, it was the being in the water that killed them.
And she fell 60, she was thrown, excuse me, not fell, she was thrown 62 feet into that water. So these details will really help the prosecution's case, I feel. Let's go back live right now with the medical examiner. Bob, you were just telling me as we were waiting to go back live and listening to this, that this is a danger for the defense and the prosecution. Can you elaborate on that a little bit?
Well, yes. I mean, the state still has an obligation to go ahead and prove its case. So it has to establish the murder, the identity of the victim, and the identity of the perpetrator. The problem with that is not going too far with graphic evidence here so that you turn the jury or get them to be a revulsive sort of reaction, but necessarily getting that information into them, which is going to be prejudicial to the defense to some extent because it's going to be very graphic and it's going to trigger emotions. But every bit of evidence against the defendant in the case is prejudicial. It's just a matter of whether it's improperly prejudicial. And here, that wouldn't be, so long as it's within the limits of what's necessary for the state to establish the elements of defense that it has to establish. Right,
and we're talking about a 5-year-old girl here, so obviously this is a very difficult case for the jury to listen to. And the idea, at one point, I mean, they're going to be identifying her from these photos. You know, how do you find a jury, if you're a defense counsel here, how do you find a jury that won't be swayed by seeing these photos or the details of what happened by Phoebe, but will just judge it based upon the facts and the law?
Well, that's a challenge here. I mean, the normal reaction is nobody's disputing that he committed this crime, really. Right. The issue in this case was he insane and therefore has a legal defense to a conviction? So the natural reaction that people are going to have on that jury, as everybody would, is that if this individual committed this act and they can punish him, this person should be punished. And they want to be able to get them away from that and be able to establish there's an alternative here.
One of the things, I mean, the jury sees him day in and day out and trying to get some glimpse of what's going on in his mind. I'm curious, though, my question is, one of the things we learned in his police interrogation tape from yesterday was the idea that, you know, he made a comment at one point saying to an officer, I think Phoebe Jade Johnchuk, is she okay? If he made that statement, he didn't realize what he did? What does that tell you?
Well, it's interesting because, first of all, he recognizes that the individual that was the victim here was his daughter and identifies that person as potentially the person he threw off the bridge. So that sort of goes against this idea that he didn't understand what he was doing.
Yeah, but if he says that, thinking, again, the legality here, the legal definition of insanity is he doesn't realize there's consequences. He doesn't understand what he did was wrong or understood what the effects of it were. That seems to suggest the defense might have a point here. The other argument of it is, do you think he's manipulating this and he knows what the law is and that he knows he wants to make himself look crazy and he's just manipulating everybody?
Well, that's the interesting argument here, you know, because it can turn everything on its head. His visits to the churches, the exorcism issue. Was this all being planned as an act of revenge against the child? Well, against the mother and his mother by killing the child. And that is That is a possibility here.
Look, they've called him manipulative. They said he's, you know, when you read about him and you hear about how the prosecution has defined him, they said he's an evil, manipulative guy. He's had a horrible, tumultuous life filled with violence and drug abuse. Is it not possible that he's making up the symptoms of what insanity would look like?
It's possible that he, knowing his past history, that he's utilizing that then to plan a defense for himself. Insanity defense, though, is a rare defense to be used because you could go to prison for life, and very rarely do defendants choose that unless, you know, either they're really insane or there's really no other viable defense. It could be the latter here because you've made the arguments on the other side.
Well, maybe, but again, you could take all of this as true and take everything that he said is true. You know, the idea that he made these statements at the church, he made this statement to the officer, really believing this, and then at the end of the day, it's going to be up to the jury to determine if these statements amount to the definition of insanity. It's an interesting legal argument. It's a tough case for a jury, especially this one, and we're going to cover it more. So let's take a quick break. When we come back, we're going to be live in the John Chuck case. We'll be right back right after this.